My name is Sarah Gross, and I'm an attorney with Veterans Legal Institute, practicing primarily in the area of veterans benefits. And this presentation is geared primarily for attorneys and gives a comprehensive overview of veterans benefits law. So you will come away with an understanding of what veterans benefits law is and what that involves and how to practice in that area. I'd just like to open with this to show what the main thrust and goal of the VA is and what we hope to achieve as attorneys working on veterans benefits. This quote is the mission statement of the Department of Veterans Affairs, or the VA. And the VA has really strived to uphold these goals, which Lincoln articulated back in 1865. Let's start with who is a veteran. We need to first understand who is a veteran for the purpose of VA benefits. So the VA defines a veteran as a person who served in the active military, naval, or air service, and who was discharged or released therefrom under conditions other than dishonorable. So when we're talking about veterans benefits and defining a veteran, that is who we are talking about. So let's start with what are VA benefits. So VA benefits are administered through the Veterans Benefits Administration, which is a specific branch of the VA. The VA has various branches, but for VA benefits, we're looking at the VBA, or the Veterans Benefits Administration. Now, there are really four main categories of VA benefits. The first is disability compensation. The next is pension, survivors benefits. And then the fourth category is other benefits. So this includes other miscellaneous VA benefits, but the three primary are the ones that we'll be covering today. There are also eligibility criteria that veterans have to establish to receive these VA benefits. The first is a veteran must have served in the 5 branches of the military. And those 5 branches are the Army, Navy, Air Force, Marine Corps, and Coast Guard. Now, if a veteran served in the Army National Guard, they must have been activated by the federal government, not by the state government, to be eligible. So notice with the National Guard, there is a federal activation component there required to make these veterans eligible for benefits. And if a veteran is a reservist, they must have been on active full-time duty or active duty for training. So if you are helping a veteran who served in either the National Guard or reservist, you need to make sure that they have met these criteria in order for them to be eligible to receive VA benefits. Moving on now to discharge characterization. So it's important to understand what a veteran's discharge characterization is to determine if they're eligible for VA benefits. So here we'll talk about a military discharge characterization and how that corresponds to a VA eligibility determination. So we'll look at kind of 2 categories: whether the veteran is honorable for VA purposes or dishonorable for VA purposes. Veterans need to have received an other than dishonorable characterization. So what does that mean? So let's take a look at this chart, which shows the various military discharge characterizations and the corresponding VA eligibility determination. So you'll notice on the left-hand side, kind of on the green areas, if a veteran received an honorable discharge characterization, a general under honorable, or uncharacterized, then they are considered honorable for VA purposes. What that means is that veterans can apply for VA benefits successfully under the VA if they have these discharge characterizations. Now, going below in the yellow, orange to red, if a veteran received an other than honorable, bad conduct, or dishonorable discharge characterization, then they are considered dishonorable for VA purposes. So this doesn't mean that they're completely disqualified, but in most circumstances, they are considered ineligible for VA benefits. So it's important to look at their discharge characterization when determining if a veteran is in fact eligible to apply for VA benefits. Now, how do we find a discharge characterization? Well, this is available through the Form DD-214. Form DD-214 is what veterans receive upon discharge from the military, and this is their discharge paperwork. So it lists their name, their rank, what date they entered in service, what date they were discharged, their date of birth. It also lists the various medals they would have received in the military. And finally, at the bottom, so we're looking at the very bottom of the form in box 24. Box 24 at the very bottom right lists the veteran's character of service. So that's where you will see if the veteran received an honorable or other than honorable discharge characterization. So when you're working with a veteran, it's always very important to ask them to share their DD-214 so you can make sure that they received a discharge characterization that entitles them to VA benefits. So we'll move on to the first category, which is disability benefits compensation. Now, there are 3 elements which must be met to prove disability benefits compensation, and we'll go into those 3 and show what a veteran must prove to establish this. And the first is that the veteran has a current physical or mental condition. So disability compensation requires that they do in fact have a condition that is a physical or mental condition. And the second criteria is the condition must have been incurred in or have been aggravated during military service. So what this typically means is that there was an in-service incident. So there was an incident that was occurring or aggravated in service relating to the condition. And that leads into element 3, which is that the veteran must show a nexus or a connection between the current condition and an in-service incident. This is the most important, I would say, element here because it requires the veteran to show not only that they had a condition and that it occurred in service, but that there's a connection between the condition and the event in service. So let's go through an example to really demonstrate that. So here we have one scenario, and this is a Navy reservist. So he was in a car accident on his way to a weekend drill and injured his back. He was treated at the ER, released and discharged. We have a copy of his DD-214, which shows that he received severance pay upon leaving the military. We also have medical records from his time in service to current, and those records contain evidence of physical therapy for his back and several back surgeries. Now, even though we have this evidence, he was denied service connection because the VA did not have evidence that the injury occurred while on active duty. So recall that a reservist needs to have been on active duty to be eligible for VA benefits. So here, even though it's apparent that he incurred an injury in service, because he was a reservist and the accident occurred while he was not on active duty, he was denied service connection. So here we're looking for, did he receive an honorable discharge? What was his rank and what was his duty in service? Was he a reservist or was he on full active duty? And did he incur an injury? And here, unfortunately, not all elements were met, and therefore he was denied service connection. So it's important to look again for all those elements to determine if this veteran can in fact successfully apply for VA benefits. Now let's talk about the first requirement for disability compensation, which is that the veteran must have a current physical or mental condition. Preferred proof of a physical or mental condition is a current medical diagnosis documented by a competent medical professional. And that is listed in the Code of Federal Regulations, and that citation is there. Now, a non-VA diagnosis is admissible in most circumstances. So even though the preference is a current medical diagnosis, it doesn't have to be by a VA professional. It can be a non-VA diagnosis. So a doctor outside of the VA system, for example. Credibility is important, so it should be someone with a medical license or medical degree giving that diagnosis, whoever the veteran's primary care practitioner is. Now, important to note that veterans without a current diagnosis may still apply for benefits, but they must include a declaration that articulates their current symptoms in order to obtain what's called a VA compensation and pension exam to determine the diagnosis. So in many scenarios, veterans without a medical diagnosis apply for benefits, but in those circumstances, the VA will oftentimes order a compensation and pension examination in which a medical practitioner examines the veteran to verify and confirm a medical diagnosis. So that is a common event or scenario that happens when a veteran applies for benefits without an active or current diagnosis. All right, now let's take a look at what competent evidence of a current diagnosis actually means and looks like. The first is a current medical record or diagnosis, and this can be medical records or mental health treatment records, which are available oftentimes in the veteran's medical file. The next is a veteran disability benefits questionnaire. Now, this is a questionnaire that the VA often uses to properly evaluate a veteran's medical diagnosis, to answer specific questions relating to how the veteran obtained that condition and really to determine what the diagnosis is. So this is often a useful tool, again, to determine a medical diagnosis. And finally, a veteran signed statement. So even if medical records or evidence is not directly available, a veteran can supply their own statement describing how they obtained the condition or diagnosis and sign that statement as competent, relevant evidence of a current diagnosis. Let's move on to the second piece or second element, which is an in-service incident. So remember that the veteran must have a condition that is incurred or aggravated during military service while on active duty. This can also be satisfied if the condition was incurred during a qualified presumptive period after active duty. And we will talk more about presumptive periods and what presumptive actually means a little bit later on in this presentation. But just to give you an overview, we have an event which can include different events that occur on base or in service, injuries, trauma. This can also involve initial symptoms and an initial diagnosis. So these are the pieces that we're looking for when we're determining or evaluating an in-service incident. As far as competent evidence of in-service incident, this again can be found in service treatment records, and if the veteran does not have immediate access to those, the veteran can request those records using a form called an SF-180. That is a specific request for military records that the veteran can fill out to obtain those records. The veteran can also access their official military personnel file. That file contains all of their records pertaining to their military service, including in-service treatment records. So that is often a helpful tool to refer to when looking for evidence of an in-service event. And again, if that veteran does not have immediate access to those records, they can request those records through filing the form SF-180. And finally, competent lay evidence. So as we'll talk about further in this presentation, competent lay evidence is admissible when filing a claim for benefits. So lay evidence could include statements or other types of records that the veteran provides to support that an in-service event occurred which led to a disability or a diagnosis. The third element for service connection is that the veteran must prove a nexus or link between the medical condition or diagnosis and the in-service event. Now, this requires oftentimes a linkage opinion or a CMP exam, and we prove this through one of 5 theories. And those theories are direct, aggravation, secondary, presumptive, and VA medical care. So the first theory we'll discuss is direct service connection. And this can be found in the Code of Federal Regulations, and the citations are there and available for you. The basic premise of direct is that a veteran must prove their current disability is directly linked to the in-service event. So there's a direct connection there. One of the greatest challenges we see is proving chronicity, or a continuity of symptomologies or consistent continuous symptoms. And I'll provide a couple of examples here to show what that means. So, for example, a veteran witnessed 4 people in her unit get severely wounded during deployment, and she now lives with PTSD. So the question is, can we prove that the PTSD is connected or linked to her time in service? So that may require some additional evidence of consistent or chronicity of symptoms of PTSD, and a reason or a statement of how that diagnosis developed specifically from her experience witnessing the wounded soldiers in service. And the second example here is a veteran developed a chronic ulcer that began during his service. So again, that would require some evidence that the ulcer developed in service, when that developed, so establishing the time frame it developed, and showing or demonstrating continuous symptoms of the ulcer condition. So can we show that the symptoms of the ulcer developed in service and have continued up to the point that the veteran applies for benefits? So those are really important things to consider in terms of proving direct service connection. The second theory is secondary service connection. So secondary is different from direct. The basic premise of secondary service connection is that any disability that is caused or aggravated by an already service-connected condition can be compensable. So what this requires is that a veteran already has a service-connected condition, and that service-connected condition causes or aggravates another condition that develops later on. So here, the greatest challenge is proving that the service-connected condition, at least as likely as not, caused or aggravated the new condition. So this is the real issue that we see with these claims, is proving that piece, that the service-connected condition caused or aggravated the new condition. So for example here, a veteran is service-connected for a right knee problem. After years of favoring her left side, she now has left knee and hip strain. So can we provide evidence that the right knee condition caused or aggravated the left knee condition and the hip strain? So here we would need kind of evidence or any kind of other statement that supports the claim that the right knee caused the later problems with the left knee and the hip strain. So that's what we're looking for in terms of developing a secondary service connection. Moving on, we'll talk about the aggravation theory of service connection. Now with aggravation, a veteran may be compensated for a disability that began before active duty, but was made measurably worse than it would have been had the disability progressed naturally. So the greatest challenge here is proving military service aggravated the natural progression of the condition. So here, we have many veterans who may have developed a disability prior to entering military service, and the military service caused that condition to worsen. So the issue here is actually proving that military aggravated the natural progression of the disease or condition. Now let's take a look at another example to demonstrate this. So the veteran entered the service with a minor left wrist problem, which significantly worsened after a car accident in service. So here we have a veteran entering the military. He already has a left wrist issue. He subsequently endured a car accident in service, which worsened the left wrist problem. So we would need to establish, to prove the claim, that the car accident caused the left wrist problem to become worse over time. And we need to further prove that the worsening of the condition is aggravated by military service that is more than the natural progression of the condition would have been. So that's the theory and an explanation here of aggravation. Now to kind of put all these pieces together, let's talk about a second scenario here. So in this scenario, we have a veteran named Fred who served in the Army for 5 years. He had a physical exam on entering the military, and the doctor noted that he had flat feet that were asymptomatic. While in the military after long hikes, he would report to sick call complaining of foot pain and limping, and he was given custom boot inserts to help with this pain. On leaving the military, he had an exit exam, and the doctor noted severe flat feet, which were now symptomatic. Current medical records indicate that he still needs custom inserts, and he states that he cannot stand on his feet for too long. So in this example, we have a pre-existing medical condition, flat feet, and notice that this condition was asymptomatic on entering the military. While this veteran Fred was in the military, he endured long hikes and subsequently developed some worsening in the foot condition, namely foot pain and limping, and that issue became so symptomatic that he was given custom boot inserts. We also see that he had an exit exam upon leaving the military, which now noted severe flat feet, which were now symptomatic. And we have relevant medical records that show the continuity of symptoms and that show that he still needs medical attention for the flat feet. So here we have enough facts and evidence to establish that the veteran had a pre-existing medical condition which was aggravated in service. So here we would likely use the aggravation theory to help prove service connection and obtain VA benefits for disability compensation for this veteran.
My name is Nancy Jones, and I'm the Senior Staff Attorney at Veterans Legal Institute. I specialize in veterans benefits, and I will be handling the remainder of the presentation today on veterans benefits. We're going to talk about the last two theories of service connection, presumption, and VA hospital care. Presumptive service connection. The basic premise of presumptive service connection is that some conditions can be automatically service connected when the veteran shows that the condition appeared within a certain time after service. Also, certain conditions are presumed to be connected to their service. We see this often in the examples of Agent Orange and Vietnam veterans. Basically, the VA concedes the nexus between the in-service event and the condition that follows service. The veteran does not have to prove a nexus between the two, making it much easier for the veteran to win their claim. Presumptive service connection has been established for many veterans who served in Vietnam and were exposed to Agent Orange. Agent Orange was an exfoliant used, sprayed all over the jungles to reduce the jungle-like environment in which the veterans were fighting. This Agent Orange was deemed toxic after years of study. So you have to have qualifying service to prove that you were exposed to Agent Orange, basically that you set foot in Vietnam during a specified period of time, or that you served off the shore of Vietnam as a Navy veteran. And some examples of conditions that have been linked to Agent Orange exposure are diabetes, prostate cancer, Parkinson's disease, different kinds of blood leukemias. Basically, the veteran needs to prove with his DD-214 that he set foot into Vietnam and that he has a condition currently diagnosed for leukemia. The VA will presume that this has been associated with his service in Vietnam and automatically award him benefits. Honoring our PACT Act expands and extends eligibility for VA healthcare for veterans with toxic exposures and veterans of the Vietnam, Gulf War, and post-9/11 eras. 20 new presumptive conditions for burn pits and other toxic exposures have been added to the presumptive list of conditions. There's also been added more presumptive exposure locations for Agent Orange and radiation veterans. This presumptive is best shown by an example. We have an Army reservist who deployed to Iraq for a year in 2004. She worked in the kitchen, which was located next to a giant burn pit where trash was burned 24 hours a day, 7 days a week. This trash included building materials, batteries, paint, food waste, bodies, old military equipment, oil, etc. Upon returning from Iraq, she felt short of breath, doing even the easiest tasks, climbing stairs, vacuuming. She is seeing a pulmonologist for her breathing condition. She was recently diagnosed with something called granulomatosis disease. She filed a claim for a breathing disorder in 2015, prior to the enactment of the PACT Act. When we filed the claim, we had to provide evidence of the toxins that were released in these burn pits in the form of studies about toxins. We had to provide maps of where she was located in Iraq to show that she was located near these burn pits. And we had to provide much evidence on her health before she deployed and much evidence on her health after she was deployed. Fast forward to 2022, after the enactment of the PACT Act, now this veteran has to provide evidence that she served in Iraq during the requisite period of time, 2004, and that she has a condition that's on the presumptive list, in this case, granulomatosis disease, which has been presumptively service-connected to burn pit exposure. This has made her claim much easier to win. Now that we've talked about the theories of service connection and how to establish a VA claim, we're going to talk about the laws that help you support that claim. Veteran law is veteran-friendly, meaning the standards of proof are lower than in other areas of law. It makes it much easier to practice veterans law. The VA has a duty to fully and sympathetically develop a veteran's claim to its optimum. VA must give a sympathetic reading to the veteran's filings by determining all potential claims raised by the evidence, applying all relevant laws and regulations. But what does this mean? Let's go back to our other veteran who had a breathing disorder. If she filed a claim for a breathing disorder, the VA has to sympathetically look at all her medical files and determine what kind of breathing disorder. Was it bronchitis? Was it sinusitis? Was it rhinitis? Was it allergies? So that's the way to sympathetically read the veteran's file. There are other legal standards that also apply in this veteran-friendly environment. We talked about it earlier, providing your medical nexus opinion. The standard is at least as likely as not, and this is only 50%. The veteran needs to prove that their condition is at least as likely as not related to that incident in service. The other legal standard that is veteran-friendly is the reasonable doubt standard. And basically, the idea is that if there's two pieces of evidence that are about 50-50 in favor or against a veteran's benefits claim, the VA has the duty to resolve the issue in favor of the veteran. And finally, as we talked about earlier, hearsay evidence is permissible. And this basically means that outside evidence, a condition happened during service, is allowed to support the veteran's claim. A family member can provide a statement even though the family member didn't actually witness it. The family member may have heard about it from the veteran, and that is sufficient evidence to establish the veteran's claim. About VA disability ratings. So the first half of the presentation, we have focused on becoming service-connected for your disabilities. But what does service-connected mean? Well, it basically means once you've been service-connected for those disabilities, the VA will give you a monthly check based on the severity of that disability. And that is based on how your disability impacts your ability to work. VA uses this disability to determine how much compensation you will receive each month. And the next slide we have is a table directly from the VA website discussing the percentage compensation that you would receive if you were a 30% rated veteran. And this veteran has one child and no spouse. And these are based on the 2022 tables. Now, there's a big difference once you are 100% disabled. Now, let's move on from disability compensation to another type of benefit you can get from the VA. And this is something known as a pension benefit. Now, a pension benefit often helps a veteran who is of low income. It's targeted to low-income veterans or surviving spouses. And there's some requirements to meet. The veteran must have served during wartime, and that length of service depends on when you served. The veteran has to have discharge that is other than dishonorable, as we talked about earlier. The veteran must also be over 65 or 100% disabled, and that disability does not have to be related to service. And that's very important because we can provide benefits compensation to somebody who's disabled but otherwise might not be entitled to disability compensation. And finally, when an elderly veteran applies for this pension, Social Security income does count as income. So the veteran may not be low income for determining pension unless that veteran has a significant amount of medical expenses that the VA is not already covering. So in that case, we would use those medical expenses to reduce the veteran's income. And this is handy for our veterans who are in requirement of in-home care or in nursing care. And please note that this is different from something called disability indemnity compensation. And that type of benefit is for a surviving spouse. Disability and indemnity compensation is paid to the spouse of a veteran who dies of his or her service-connected disabilities. Hopefully we've convinced you to take a veteran's benefits claim from VLI as a pro bono attorney. If so, there are a number of questions that you can ask a veteran to get started. Have you filed for VA benefits before? If so, do you have a copy of that decision letter? Do you have a copy of your DD-214? If so, can you provide us with that copy? Were you injured in service? If not, we may be looking at filing a pension for the veteran. and that would require different steps. If so, it will impact the type of evidence that we collect on behalf of that veteran. Finally, do you still have a copy of your military records? If not, we can request one for you or obtain a power of attorney to assist you in obtaining a copy that we can review. Let's say the veteran filed for benefits, but the veteran is unhappy with his decision. How can we help that veteran? Some of the reasons a veteran is unhappy for their decision is because they weren't rated for all their injuries, she wasn't rated high enough, he wants an earlier effective date, or she was denied service connection. If the veteran filed a claim and was denied, we needed to know how long ago the veteran was denied. If the veteran was denied his claim less than a year ago, there are two appeal options. The first appeal option is a supplemental claim, and that's if the veteran has new and relevant evidence to support their claim. The second option is a higher level review, and if the veteran has no additional evidence to support their claim, but it seems like the denial was incorrect, we would file that higher level review. We need to know if the veteran has the decision letter, and we would review the decision letter for the date of the decision and for the reason of the denial of the claim. Please note, if the claim was denied more than a year ago, it does not mean the veteran cannot file a claim for disability. A veteran's claim for disability can always be appealed. There's no statute of limitations on a veteran's claim. However, it will impact whether or not the veteran will get an earlier effective date. So let's say we're helping the veteran file a supplemental claim. We'll need to help the veteran provide new and relevant evidence to support that claim. New evidence is evidence that the VA has not seen since the previous decision. Relevant evidence is evidence that is important to help the veteran support his claim. Let's say the veteran was denied because he didn't have proof of an in-service incident. Relevant evidence would be the veteran's statement or service records providing support of that in-service incident. We can determine what is needed by reviewing the VA's decision letter and their reason for denial. A higher level review is also a type of claim that we can file on behalf of the veteran. This allows a senior reviewer at the VA to take a new look at the case and to determine whether the decision can be changed based on a difference of opinion or an error. The veteran can request a higher level review of an initial claim or a supplemental claim decision. The option is unavailable after a previous higher level review or a board of appeal on the same claim. If the veteran has filed a supplemental claim and a higher level review and been unsuccessful, we can appeal the veteran's claim to the Board of Veterans' Appeals. This is the first time that a claim will be looked at by an attorney and by a judge, and the veteran can request a hearing in front of the board. It's important to remember that the board is veteran-friendly and there's no cross-examination of the veteran. It is evidence gathering only. It's not adversarial in nature. It allows the veteran to explain his claim or her claim, and it also allows the attorney representing the veteran to provide a legal sound argument why the veteran's claim should be connected to service or should be rated higher. If the veteran loses at the Board of Veterans' Appeals, they have one last recourse at the United States Court of Appeals for Veterans Claims. VLI does not normally handle cases in front of this court, and the court would be reviewing decisions by the Board of Veterans' Appeals. Veterans Legal Institute is a nonprofit law firm located in Orange County. We represent veterans in Orange County, Los Angeles County, San Bernardino, and Riverside counties. The veteran is a low-income veteran in need of legal services. Veterans benefits, discharge upgrades, family law, and housing are our primary areas of practice. If you are interested in helping a veteran, please reach out to VLI and take a claim for veterans benefits. You can change a life by helping the veteran file his disability claim or appeal his disability claim.